All right, welcome back. I've been distracted recently. I've been watching the Gwyneth Paltrow trial since it's local, and unfortunately, I only managed to make it to the courthouse once because Mother Nature apparently was against me. It just would not stop snowing, and Parley's Canyon is it's scary in the snow. I tried to get up there on Friday to watch Paltrow testify, and I turned around at the first exit because it was frightening. So that said, I'm back. The trial's over. She won her dollar. Uh, and I've got a fun one for you today. So this was sent to me by Dog Detective. So everyone give an ow to Dog Detective in the chat. It's Afroman, which is a blast from the past. Brings me back to my senior year of high school. For those of you who don't know, he did the song "Because I Got High." It was released in the summer of 2001. Um, Before I do that, though, let's talk Delete Lawz. So there's been a little activity in his California state court suit. Nothing worth a video, I've thought. I'm just going to be brief. He's had problems with service. He's trying to get a default judgment against Daniel Clement, which has been denied by the court clerk either 3 or 4 times because he can't fill out the form right. But but even if he does fill it out right, he's got problems. I don't think that Daniel Clement has been served, but I'm not going to go any deeper than that because I don't want to give him any hints. He's trying to get substitute service on Kate or on Blue Bacon. He's trying to claim that Kate's dodged service, so therefore she should be considered served. I don't think any of that's going to fly, but once again, with that, I don't want to give him any extra help. So I'm just going to leave it at he's got problems. With that, I told you it'd be brief. Let's jump into Afroman. So, a year ago, I think, 2 years ago, Afroman was raided at his Ohio home by the police. They were looking for drugs and they were looking for kidnapping victims. And they didn't find anything. They no knock raided his house. They rammed a truck through his front gate. They blew the front door off its hinges. It was a mess. And they didn't find anything. So Afroman's security cameras and his wife, who was there, recorded on her cell phone and the security cameras. So Afroman made a whole album out of the incident called I believe it's called Lemon Pound Cake. And the main song on it is "Are you going to help me replace my door and gate?" I'm not going to play it here. You should go watch it. It's on YouTube. It's hilarious. Um, it also explains why the album's called Lemon Pound Cake. Uh, so the cops are not happy about it. And so they're suing him for unauthorized use of their likeness and for what amounts to defamation claims. And it's a whole mess. Let's just say when people say ACAB, all cops are bastards, they are specifically talking about these cops. They are awful. They are the absolute worst face of policing, short of, Derek Chauvin and his ilk. They it's astounding. And it's all the more galling because Afroman suffered damages. His house was damaged. They stole his money, but because he caught it on video, it was returned. But they stole his money. They disconnected his security cameras. Is that a civil rights First Amendment violation? I think so. So he suffered damages. But these cops, if he were to sue, they'd claim sovereign immunity. The government, the police department would claim sovereign immunity. These cops would claim qualified immunity. So Afroman's not getting paid. They're not repairing his house. They're not repairing his door. But he's in the fortunate position that he's a public figure. He's able to monetize this invasion. And he has. So that's paid for his door. But these dirty cops don't like that. So they're going after him. So with that, let's take a look at the complaint. In the Court of Common Pleas of Adams County, Ohio, it was filed March 13th of 2023. And the dirty cops are Sean D. Cooley, Justin Cooley, Michael Estep, Sean Grooms, Brian Newland, Lisa Phillips, and Randolph L. Walters Jr. They are the dirty cops who do not like that Afroman has publicized them being dirty cops. So I figure a little Streisand effect is in order. So those names again: Sean D. Cooley, Justin Cooley, Michael D. Estep, Sean D. Grooms, Brian Newland, Lisa Phillips, and Randolph L. Walters Jr. versus Joseph Edgar Foreman, aka Afroman, and Hungry Hustler Records and Media Access Inc. and defendant John Doe's 1, 2, and 3. And this is a complaint for damages and injunctive relief with jury demand endorsed hereon. I've got news for these dirty cops. This is never going before a jury. If ever there was a case that would be dismissed on Ohio's state version of a 12b6 motion to dismiss for failure to state a claim or summary judgment, this is one. And frankly, I'd be surprised if they don't pay Afroman's legal fees in the process, because this is, well, they're they don't have qualified immunity as cops suing him. This is in their private capacity. So they won't have qualified immunity to protect them from paying his legal fees. So for their complaint against Joseph Edgar Foreman, aka Afroman, Hungry Hustler Media, Hungry Hustler, Media Access, John Doe 1, John Doe 2, and John Doe 3. Plaintiffs: Dirty Cop Sean D. Cooley, Dirty Cop Justin Cooley, Dirty Cop Michael D. Estep, Dirty Cop Sean S. Grooms, Dirty Cop Brian Newland, Dirty Cop Lisa Phillips, and Dirty Cop Randolph L. Walters Jr. state as follows. Parties: Cooley is with the Adams County Sheriff. Both Cooleys are. Estep is with the Adams County Sheriff. Grooms is with the Adams County Sheriff. Uh, Newland is the detective sergeant with the Adams County Sheriff. Phillips is a deputy with the Adams County Sheriff. Uh, Walters is a sergeant with the Adams County Sheriff. And defendant Joseph Edgar Foreman, aka Afroman, is an individual residing in Adams County, Ohio. Defendant Hungry Hustler Records, on information and belief, is a business entity doing business in and with its principal place of business in Adams County, Ohio. On information and belief, Hungry Hustler is owned and operated by defendant Joseph Edgar Foreman and is used by defendant Foreman to market and sell music, videos, merchandise, and other products. Defendant Media Access Inc., on information and belief, is a Texas corporation in the business of full service video and music distribution and royalty collection. On information and belief, Joseph Edgar Foreman uses Media Access Inc. to distribute his music and media posts to collect royalties and for other services. Through its distribution of videos and music in Ohio and its business dealings with defendant Foreman and others in Ohio, Media Access Inc. has significant contacts with the state of Ohio. Defendant John Doe 1, on information and belief, is a business entity doing business in and with its principal place of business in Adams County, Ohio. On information and belief, defendant John Doe is owned and operated by defendant Joseph Edgar Foreman. I'm just going to say Afroman from now on, and is used by Afroman to market and sell music, videos, merchandise, and other products. Defendant John Doe 2, on information and belief, is a business entity doing business in and with its principal place of business in Adams County, Ohio. On information and belief, Hungry Hustler is owned and operated by Afroman and is used by Afroman to market and sell music, videos, merchandise, and other products. Defendant John Doe 3, on information and belief, is a business entity doing business in and with its principal place of business in Adams County, Ohio. On information and belief, Hungry Hustler is owned and operated by Afroman and is used by Afroman to market and sell music, videos, and merchandise and other products. Factual background: Afroman, in quotation marks, products and merchandise. Defendant Joseph Edgar Foreman, or I'm going to call him Afroman, like I said, is a creator, producer, and performer of music and videos who is known by the stage and commercial name Afroman. In addition to music and music videos, Afroman markets and sells a variety of products under the trade name Afroman. These products include beer, marijuana, t-shirts, and other merchandise. Foreman sells his Afroman products online and at live events at which he performs. Search of defendant Afroman's residence. On or about August 21st, 2022, law enforcement officials from Adams County Sheriff's Office conducted a search of Afroman's Adams County residence pursuant to a lawfully issued search warrant. Afroman was not present at the time of the search, but his wife was in the home, observed the search, and recorded portions of the search on her camera phone, including the faces and bodies of many of the law enforcement officers involved. You have a legal right to film the police in the process of conducting their duties. Uh, For Afroman's residence was equipped with several security video cameras, which also recorded many portions of the search, including the faces and bodies of many of the law enforcement officers involved. Until said dirty sheriff's deputies disconnected those security cameras. Afroman creates commercial videos with faces and bodies of plaintiffs. I mean, they just gloss over that they didn't find the drugs. They didn't find the kidnapping victims. They didn't find the drug paraphernalia. They did steal his money, and they did buy his lemon pound cake. Foreman creates commercial videos with faces and bodies of plaintiffs. After the search was concluded, Afroman used portions of the recordings of the search from his wife's phone and his surveillance cameras to create music videos about the search. There is These music videos clearly portray the images, likenesses, and distinctive appearances, personas, of many of the officers involved in the search, including those of all plaintiffs. Afroman created dozens of videos and images of plaintiffs' personas and posted them on various social media platforms, including Facebook, YouTube, Snapchat, TikTok, and Instagram. Afroman has used and continues to use the videos and photos of the plaintiff's personas for commercial purposes to promote his Afroman brand, to sell products, to promote his music tours, and to make money from the use of plaintiff's images on videos and other media. Following are only some of the many examples of the defendant's use of the personas of plaintiffs for commercial purposes. Instag- Instagram post containing an image of Foreman wearing a shirt with an image of plaintiff dirty cop Sean Cooley beside an image of Peter Griffin from Family Guy. Caption: Good morning, ladies. What up, fellas? Congratulations to police officer Pound Cake. Thank you for getting me 5.4 million hits on TikTok. I couldn't have done it without you, obviously. Congratulations again. You're famous for all the wrong reasons. As you can see, all my pound cake is gone. Officer Pound Cake confiscated my pound cake. He said something happened to his body camera on the way to the evidence room. LOL. In- Instagram post containing images of fans holding merchandise that contains images of Dirty Cop Sean Cooley. Caption: Lemon Pound Cake. Instagram post in which Afroman confirms that at OG Afroman is his official account. Post contains images of plaintiff Dirty Cop Brian Newland, then advertises Afroman's new album. Instagram post containing image of Afroman wearing a shirt with images of Dirty Cop Justin Cooley. Post promotes new album. Caption: What's your favorite song on Lemon Pound Cake so far? Also, what's your favorite line? Instagram post containing image of Afroman wearing merchandise and promoting merchandise with images of Dirty Cop Sean Cooley. Caption: I am pressing up merchandise for my up and coming Canada tour. Which Officer Poundcake shirt do you like the most? The one on the left or the right? Let me know so I invest my money in the more popular shirt. Instagram post containing images of merchandise. Some of the merchandise contains images of Dirty Cop Sean Cooley. Caption: Canada, get ready for the most hunted to the most wanter, the most blunted rapper in the world. For the first time, I will have brand new merchandise available on the month-long Canada tour. Bring ya merchandise money. I will sign everything that is bought. T-shirts $35, hoodies $70, binnies $30. Instagram post containing video of fans and defendant singing Lemon Pound Cake while a fan wears merchandise that contains images of Dirty Cop Sean Cooley. Interview on Vlad TV during which Afroman discusses the use of the search as material for songs. Afroman admits to using images and clips from the search in videos and promotion. Afroman states that his Will You Repair My Door song went viral. Afroman states that his Lemon Pound Cake clip went viral on TikTok. Afroman says, Everybody understood what I was talking about when I said lemon pound cake. That's the cop on the viral video, TikTok, that was going through the house that wanted a slice of the lemon pound cake. Includes image of Dirty Cop Sean Cooley on the video. Instagram post that portrays Dirty Cop Sean Grooms next to an image of Quasimodo, the Hunchback of Notre Dame. Caption: Good morning, ladies. The Hunchback of Adam's KK KKK County said to get my new album, Lemon Pound Cake, September 30th. Instagram post that portrays Judge Gabbert, the judge who signed the search warrant, next to an image of Droopy. Caption: This is the judge that signed the warrant that said kidnapping. His name is Roy Droopy Gabbert. Vote him out before he signs a fictitious warrant, then sends some overreacting paranoid KKK cops to your house, jeopardizing the lives of you and your family, stealing your money, and disconnecting your home video security surveillance system. Vote out Roy Droopy Gabbert. Then go get my new album, Lemon Pound Cake, September 30th on all platforms. That album came out fast. That's just over a month. That's impressive. Instagram post that portrays dirty cop Lisa Phillips next to an image of the Mona Lisa. Good morning, ladies. Here she is, the condescending C word, Adams KKK County Sheriff, Lieutenant Mona Lickum Lao Lisa, to serve and disconnect your home video security surveillance system so you won't have proof of the Adams County Sheriff Department stealing money and other things around your house, even possibly planting false kidnapping evidence. I used to speak to this lady when I dropped my kids off to school. I always wondered why she never spoke back, just looked at me with the same condescending C word look you see in the picture. I spoke to her again at the metal detector in the Adams County Courthouse. Her voice was 3 octaves lower than mine. LOL. Has anybody in Adams County verified her vagina? If you haven't, you should, or she might whoop out something bigger than yours. Oh, that's a low blow. Sorry. If this lady is your friend, I wouldn't leave her alone in my house. Or I'll put it this way, if you leave and your video system is messed up when you get back, you know who did it. Why would a good cop want to disconnect a video security surveillance system? Lieutenant Lickum Low Lisa, new album, Lemon Pound Cake, dropping September 30th. My name for this particular officer is Lieutenant Mona Lickum Low Lisa. What nickname did you come up with for her? I'm good with, I'm good, but I will admit yours might be better than mine. What you got? YouTube videos depicting most or all of the officers involved in the search, set to music and used by Foreman to promote his brand and sell his products. That's quite a laundry list of social media posts. Afroman created many other videos posted on various social media platforms that use the personas of each of the plaintiffs for commercial purposes. That is, to promote his live performances, his music, his other merchandise, and his Afroman brand. Foreman created, performed, posted, and publicized these and other depictions of plaintiffs' personas for commercial purposes without the authorization of any of the plaintiffs to do so. Afroman created, performed, posted, and publicized these and other depictions of plaintiffs' personas for commercial purposes through, in cooperation with, or with the assistance of the other defendants, all of whom knew that the use of plaintiffs' images and identifying characteristics was not authorized by plaintiffs. Defendants' actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of the plaintiffs. Did they consciously disregard the rights of Afroman? I mean, as a result of defendants' actions, plaintiffs have been subjected to rightful ridicule, even in the further performance of their official duties, by members of the public who have seen some of defendants' above described postings. In some instances, it has made it more difficult and even more dangerous for plaintiffs to carry out their official duties because of comments made and attitudes expressed towards them by members of the public. If you live in or frequent Adams County, Ohio, and you see any of these defendants, be sure to ask them how they like their pound cake. I mean, don't do the whole First Amendment auditor thing. Don't interfere. Don't interfere with stops. Don't. But ridicule is always appreciated. Dirty cops always need to be ridiculed. As a further result of Afroman's actions, plaintiffs have been subjected to threats, don't threaten them, including death threats by anonymous members of the public who have seen some of defendant above described postings. Obviously, don't threaten. That's a jackass move. Just don't do it. As a result of defendants' actions, plaintiffs have suffered damages, including all profits derived from and attributable to defendants on the unauthorized use of plaintiffs' personas, and have suffered humiliation, ridicule, mental distress, embarrassment, and loss of reputation. Plaintiffs continue and will continue in the future to suffer damages unless defendants are enjoined from further violations of plaintiffs' rights. I mean, because it's set to music and by a celebrity, it's humiliation, ridicule, mental distress, loss of reputation. If he had just posted the security cameras and not collected a penny, they'd still be suing because they are that kind of dirty cop. They don't, I mean, I can't remember who said it, but sunshine is the best disinfectant. Exposing dirty cops is the best disinfectant. If you can do it to catchy music, all the better. Count 1. Violation of Ohio Revised Code, Chapter 2741. Unauthorized use of individual's persona. Now, this is the only one of the statutes I looked up. And I'm glad I did. I didn't need to, per se, because let's just say the First Amendment is a thing. And this is exactly the type of speech that the First Amendment protects. So, this, even if this law didn't have exceptions, a federal court would chuck this out. I mean, this is a clear First Amendment violation. But we don't have to get that far. Here's why. So, looking 274101 is the definition section. That's usually the first section. Okay, what? Apparently I hit something. Let's wait. There we are. So we have 274101 is the definitions, and then O2 is the law. O3 is the application to residents of this state. Uh, Several others. O9 is exceptions. We'll get to that in a second. So, definitions as used in this chapter. It's funny how sovereign citizens always run to Black's Law Dictionary to define driver when laws almost always have a definition section right at the top. So, for example, the first definition here persona means an individual's name, voice, signature, photograph, image, likeness, or distinctive appearance if any of these aspects have commercial value. Well, so if Black's Law Dictionary has the definition of persona and it's different, the court's going to use this definition because it's the one lawmakers intended. So, commercial purpose means the use of or reference to an aspect of an individual's persona in any of the following manners: on or in connection with a place, product, merchandise, goods, services, or other commercial activities not expressly exempted under this chapter. For advertising or soliciting the purchase of products, merchandise, goods, services, or other commercial activities not expressly exempted under this chapter. For the purpose of promoting travel to a place, for the purpose of fundraising. Name means the actual, assumed, or clearly identifiable name of or reference to a living or deceased individual that identifies the individual. So, Officer Pound Cake wouldn't count. Right of publicity means the property right in an individual's persona to use the individual's persona for commercial purposes. Uh, blah blah blah. So, I think the most important definition is persona and commercial purposes. And persona, something I think these dirty cops left out, if any of these aspects have commercial value. I don't think the cops, absent Afroman, there is no commercial value in their name, at least none that I'm aware of. So that's going to be a problem for them. But let's look at the statute. Got 274102. Except as otherwise provided in this section, a person shall not use any aspect of an individual's persona for a commercial purpose during the individual's lifetime, for a period of 60 years after the date of the individual's death, or for a period of 10 years after the date of death of a deceased member of the Ohio National Guard or the Armed Forces of the United States. A person may use an individual's persona for a commercial purpose during the individual's lifetime if the person first obtains the written consent to use the individual's persona from a person specified, blah, blah, blah. If an individual whose persona is at issue has died, a person may use the individual's persona for commercial purpose if either of the following applies. So, B doesn't apply. No permission's been granted. None of them are dead, so that doesn't apply. C, subject to the terms of any agreement between a person specified in section 274105 of the revised code and a person to whom that person grants consent to use an individual's right of publicity. A consent obtained before the death of an individual whose persona is at issue remains valid after the individual's death. So their heirs can't revoke that permission pursuant to the contract. So, for the purposes of this section, a use of an aspect of an individual's persona in connection with any news, public affairs, sports broadcast, or account does not constitute a use for which consent is required under Division A of this section. A use of an aspect of an individual's persona in connection with any political campaign and in compliance with Title 35 of the revised code does not constitute a use. The owners or employees of any medium used for advertising, including but not limited to a newspaper, magazine, blah, 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 are not liable under this section. So, the important thing, except as otherwise provided in this section, you can't. The exceptions would be the except as provided. So, this chapter does not apply to any of the following. 1. A literary work, dramatic work, fictional work, historical work, audiovisual work. Is Afroman's music video audiovisual? Or musical work, regardless of the media in which the work appears or is transmitted, other than an advertisement or commercial announcement not exempt under Division A1D of this section. That's 1A. That's an exemption. That's going to get this thrown out. But 1B, material that has political or newsworthy value. The political speech is the highest level of protection. This is political speech, criticizing the government and its agents. And it's newsworthy. Afroman getting rated is newsworthy. He just set it to music, which means we've got exemptions under 1A and 1B. 1C, original works of fine art. 1D, an advertisement or commercial announcement for a use permitted by Division A1, A, B, or C of this section. So I think the only place that Afroman might might run into trouble on this is selling merch, t-shirts, hoodies. Um, but I'd still argue this is political speech. I'm selling this to raise awareness of the dirty cops in Adams County, the dirty sheriff's department who raided my house, which is a newsworthy event. I'm spreading awareness. This is protected First Amendment speech. My money's on that working. But let's read count one. Plaintiffs repeat the allegations, blah, blah, blah. Defendants used the personas of the plaintiffs for commercial purposes during plaintiffs' lifetimes without their authorizations to do so. The personas of the plaintiffs were not used by defendants in connection with any news, public affairs, sports broadcasts, or political campaign, and their unauthorized use of plaintiff's persona for commercial purposes was not justified or excused. It doesn't say it has to be used for the news. Material that has political or newsworthy value. Political or newsworthy value. Not political campaign or news broadcast. Do you guys see the difference? It has political or newsworthy value. Not to report on the news, it has newsworthy value or political value. There is a difference. All defendants had knowledge of the unauthorized use of plaintiff's personas as prohibited by Revised Code Section 274102. Defendants' actions constitute the unauthorized commercial use of plaintiff's personas in violation of Revised Code 274102. Defendants' actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of the plaintiffs. As a result of defendants' violations of the statute, plaintiffs have been damaged in the amount of profits made by defendants by the unauthorized use of their personas, have suffered embarrassment, ridicule, emotional distress, humiliation, and loss of reputation, and are entitled to injunctive relief and other remedies under the statute. Count two, invasion of privacy by misappropriation. This one's not going to work either. Did I freeze? All right. I think I froze for a minute, but I'm back. I just said this one is not going to work. The, the invasion of privacy by misappropriation, restatement of torts, section 652C from 1977. Plaintiffs repeat, blah, blah, blah. In using plaintiffs' personas as alleged herein, defendants have appropriated for their own use and benefit the reputation, prestige, social standing, public interest, and other values of plaintiffs' names and likenesses, which have intrinsic value in contravention of plaintiffs' rights to privacy. When you are a cop in your official duties, you don't have a right to privacy. The public has a right to film you. They have a right to to blast it across all media. You do not have a right to privacy. You invaded Afroman's privacy by busting down his door. That's the invasion of privacy. I mean, I'd love to see the probable cause affidavit. I want to see who swore out that affidavit. What evidence they brought to the judge. Defendant's actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of plaintiffs. As a result of defendant's invasion of privacy by misappropriation, plaintiffs have been damaged monetarily and have suffered embarrassment, ridicule, emotional distress, humiliation, and loss of reputation, and are entitled to injunctive relief and other remedies. Count 3, invasion of privacy, false light, publicity, restatement of torts, second, section 652E. Once again, he did not invade their privacy. They were doing a public job in his private property, uh, and false light, making fun of a chubby sheriff's deputy or sergeant, whatever, for eyeing a pound cake. Well, that's parody. It's not false light. False light for stealing his money that was caught on camera and not disclosed until Afroman put out the video, and then you said, "Oops, we have your money here. Here you go. We're returning your money." Is that false light publicity? In their depictions and descriptions of plaintiffs on social media postings and elsewhere, defendants made statements that were false and that they knew to be false, and which portrayed plaintiffs in a false light, subjecting them to undue ridicule, embarrassment, and mental distress and danger. Defendants' actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of plaintiffs. As a result of defendants' false depictions of plaintiffs, they have suffered embarrassment, ridicule, emotional distress, humiliation, and loss of reputation, and are entitled to injunctive relief and other remedies. I mean, they haven't even said, both in this section 4 count 3 or in the narrative sections above, what's false. That they say false light portrayal. What's false? What lies has Afroman told? Count 4, invasion of privacy, unreasonable publicity given to private lives. Restatement, second of torts, section 652D. Some of defendants' postings, as described above, gave publicity to matters concerning the private lives of plaintiffs, which were not of legitimate concern to the public, and the exposure of which a reasonable person would find to be highly offensive. Defendants' actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of plaintiffs. As a result of defendants' unreasonable publicity of the private lives of plaintiffs, they have suffered embarrassment, ridicule, emotional distress, humiliation, and loss of reputation, and are entitled to monetary and injunctive relief and other remedies. I mean, what? Other than saying he'd spoken to the one dirty cop at their kid's school, ha- has there been anything else that isn't about them on the job? Count 5, injunctive relief. As described above, Defendants continue to violate plaintiffs' rights and subject them to undue ridicule, mental distress, and danger by posting untrue and demeaning depictions of them on social media and elsewhere. Unless defendants are restrained, plaintiffs will suffer irreparable injury to their reputations, their mental health, and their legally protected rights as defendants continue to willfully and maliciously violate those rights. The continuing injury to plaintiffs outweighs any potential injury to defendants that would result from an injunction. The requested injunctive relief is not adverse to public interest. Plaintiffs have a substantial likelihood of success on the merits of their claims. No, they don't. Plaintiffs should be preliminarily and permanently enjoined from continuing to violate. Plaintiffs should be preliminarily and permanently enjoined from continuing to violate plaintiffs' rights. I agree. The plaintiffs should be enjoined from continuing to violate defendants' rights and from posting their personas for commercial purposes, posting false information and information that puts plaintiffs in a false light, and posting unreasonable private information about them. Wherefore, plaintiffs demand judgment against all defendants as follows. On count one, against all defendants, jointly and severally, an award for actual damages in excess of $25,000 in the amount of profits made by defendants by the unauthorized use of plaintiffs' personas, or in the alternative, for monetary damages as provided by statute, for punitive or exemplary damages, for their attorney's fees, costs of and expenses of litigation, for permanent injunctive relief, for impoundment of merchandise, goods, and other materials, and or their destruction as provided by revised code section 274107D and E. On count two, against all defendants jointly and severally, an award for actual damages in excess of $25,000 in the amount of profits made by defendants by the invasion of their privacy, for damages for the emotional distress, embarrassment, ridicule, loss of reputation, and humiliation suffered by plaintiffs, for punitive or exemplary damages, and for their attorney's fees, costs, and expenses of litigation. On count three, against all defendants jointly and severally, an award for actual damages in excess of $25,000 in the amount of profits made by defendants uh, by the invasion of their privacy, for damages for the emotional distress, embarrassment, ridicule, loss of reputation, and humiliation suffered by plaintiffs, for punitive or exemplary damages, and for their attorney's fees, costs, and expenses of litigation. On count four, against all defendants, jointly and severally, an award for actual damages in excess of $25,000 in the amount of profits made by defendants by the invasion of their privacy, for damages for the emotional distress, embarrassment, ridicule, loss of reputation, and humiliation suffered by plaintiffs, for punitive or exemplary damages, and for their attorney's fees, costs, and expenses of litigation. I feel like a broken record. On count five, an order permanently enjoining all defendants from continuing to violate plaintiffs' rights and from publishing plaintiffs' personas for commercial purposes, publishing false information and information that puts plaintiff in a false light, and publishing unreasonable private information about them. As to all counts, for their costs, attorney fees, and all other relief to which they may be entitled. Jury demand, plaintiffs demand a trial by jury on all issues so triable. Respectfully submitted by Robert A. Klingler of Robert A. Klingler Co. LPA, the attorney for the plaintiffs. Yikes. As I said, I absolutely think this one is dead in the water. Do not pass go. Do not collect $100. It it's a bad suit. This attorney should be ashamed of himself. These dirty cops should be even more ashamed of themselves. Um, I absolutely think Afroman wins very soon. No way it goes to trial. I hope he gets a lot of attorney's fees, as in collects attorney's fees from the dirty cops. And as I said, these cops, they're worried about the damage to their reputation. So go damage it further. Go watch the videos. Go, like I said, if you're in Adams County and you see them, hold up posters of lemon pound cake, make oinking noises, just ridicule them. Don't interfere with their traffic stops, don't interfere with their duties, but absolutely ridicule them. Let's change the name from the Streisand effect to the Afroman effect, to the lemon pound cake effect, because these morons, these absolute morons, this is the Streisand effect. I would not have seen lemon pound cake. I would not have seen "Will you help me repair my door?" if they hadn't brought this suit. I wouldn't have seen it. So, it was these cops, these dirty sheriff's deputies bringing this frivolous suit that brought them to my attention, and I'm sure it's the same for a lot of you out there. So, yeah, that I think I don't have much else to say on that. Like I've said, I think Afroman wins pretty easily. Uh, don't bring frivolous suits, especially against celebrities, if you want to stay anonymous. I mean, uh, I mentioned at the beginning, I was distracted for the last week or so with the Gwyneth Paltrow trial here in Utah. It Terry Sanderson, the plaintiff in that case, he said after, it wasn't worth it. I'm going to live on the internet forever now. It wasn't worth the embarrassment. He's not talking about losing the case, whether it was worth trying it. For him, it wasn't worth the notoriety of going up against a celebrity. Now, Afroman isn't a Gwyneth Paltrow level celebrity, but these cops are going to know exactly what Terry Sanderson was talking about when he said it wasn't worth it. With that, I hope this video is worth it. So please like, share, subscribe, do all the fun YouTubey things, and I will see you all soon. Thanks for joining me. Bye bye.